Hi guys, this is Eric and Don again. So we want to take a step back and not focus on all of the changes that have been implemented recently as of July, but really focus more on the basics of real estate. And one of the first core things is ratification. What is it? So I wanted to put in front of Don the following situation. I'm a brand new realtor. I come in and I asked Don the following question. Don, I thought we were ratified. Everybody signed everything. I hadn't received it back yet, and then the other side accepted a different offer.
Right.
How is that possible?
Yes, the ratification is tricky because it has several components. Part of it is, at its base, is an agreement between the parties on all the offerings in a contract, right? So sales price, loan amount, closing date, all those things are accepted. The problem is how it's articulated, okay? And this can vary from state to state, but in Virginia, it's not really ratified until it's delivered, okay? So until I get the agreement, so you sign it and then I get it. When I get it, that's when we have ratification.
Okay, so it's hinged on delivery. I mean,
it's hinged on delivery, right? And so you have a ratification date in the contract. And as you know, on the NVR, for example, NVAR contract, at the end, there's a date of ratification. There's a big box. So even if that wasn't filled out, what we're looking for is when it was signed last and when that was delivered. So you're looking for that critical date because all your timelines flow off the date of ratification.
Got it. I think I understand now. Another one of the things we wanted to talk about was the difference, the impact between the template language that's already included in the NVAR and the VAR contracts and the language that agents sometimes strike through, as well as write in there themselves in other terms and what have you, as you're filling in the blanks. I never understood really what supersedes the other. Is there some kind of, does one carry more weight?
It can. So yeah, I mean, template's a great word, right? So VAR has a contract, NVAR has a contract, DAR, wherever, there's all these versions of language. Those are considered template languages, right? So anytime I modify those, one of the first things we're looking for is, can we determine what was last in time? So if I have template language and someone handwrites something, it's pretty obvious what's last in time, right? Because you had the template before you could handwrite. So in those situations, handwritten controls. Now, if you had typewritten and handwritten, kind of to your point, if someone struck through and then maybe they typed it in because we're starting to have the ability, we have writable PDFs and the agents can really get in there and type it versus handwriting it. What if we have typewritten and handwritten? So then we really got to figure out what's last in time. If we can't determine that for some reason, which would be a little bit unusual, right? We couldn't figure out when the last one was.
Yeah.
Handwritten would control.
Okay.
So it's template, typewritten, handwritten. But really last in time is what we're searching for because last in time controls. So anytime you have a contract, the addendum that are behind it, those control. And it's always going to be last in time.
Gotcha.
Yeah.
That makes more sense. Thanks, man.
Mm-hmm.
The last thing we wanted to talk about as we're focusing on basics is actually ties a little bit more to some of the changes that have occurred in the recent addendum that have come out, in particular the appraisal addendum,
Right.
And how it applies to counteroffers.
Mm-hmm.
Can you take a step back and accept a previous offer that's
Right.
been provided to you? A lot of agents feel like you can. We offered this to them, and then you've gone back and forth a couple times, but we'd like to take a couple steps back. Can you do that? Is that valid? Is the previous offer still valid?
Right. So yeah, offers and counteroffers. We saw it with the home inspection contingency, and now we're seeing it with appraisal. Is we have this negotiation period where as many offers and counteroffers as the parties want can be made, and how do we accept those things, and how do we negate those things? So if Eric makes an offer to me and I make a counter, so if he offers me $1 and I counter with 50 cents, I've killed his offer of $1, right? So anytime you make a counter on an existing offer, you kill the offer. So you can't retroactively go back and accept. So in that case, if I retroactively accepted your $1, I'm actually making a counter so that you have to accept that. So you have to be really mindful of that as you move through these things because we get caught up in the day-to-day and we get micro instead of macro in how we view. And with the contract stuff, if you end up in court, they're going to look at how do they interpret the contract and all the contractual rules that go along with it. So they're going to be really focused on how you operated versus what your intent was. So offers and counteroffers can be really, really challenging. Just pay attention to it and make sure you move through that timeline properly. And if you have questions, we're here. Your broker's there to help.
Yeah. Thanks, guys. Appreciate your time. Hope you learned something.